Hello, good afternoon. Today is January 8th, 2025. My name is Kim Christian. I'm here at the Russo Law Group, and I'm happy to welcome you to my webinar today. 2025, From Goals to Action, Essential Estate Planning for 2025. I'm looking forward to starting the new year with all of you. I feel very lucky to be the first presenter of our webinar this year. So I'm going to share my screen right now. That way we can all look on for some housekeeping items and then move through the program. I think you'll find it's a robust program and very important for the new year. So let's get started. All right, essential estate planning for 2025. And just a few housekeeping items that we find very important. To minimize background noise, your mics have been muted. Please use the question and answer box to submit any questions. I'll address them at the end of the presentation. You're welcome to communicate with myself or other attendees using the chat box. The webinar is being recorded, and we will email you a link to the recording afterwards. And lastly, of course, we value your feedback, so please let us know how we did in the survey, which will appear on your screen at the end of the webinar. All right, so who am I? Most of you know me already, or some of you know me already, but for those who don't, my name is Kim Christian, as I said earlier. I'm a partner with the Russo Law Group. I've been here with this law firm alone for over 17 years, and all of my partners and the staff are highly seasoned as well. So our experience is, of course, your protection. I'm a lead planning attorney in the Lido Beach office. I also work out of the Garden City office, but we also have another location in Islandia, which is very convenient for all areas of Long Island and New York City. Our practice areas include elder law, special needs planning, Medicaid, estates and trust planning. So we are your planners if you have anything regarding those matters. And then there's a few things. I was recognized as lawyers of distinction, and I belong to some professional organizations like the bar associations. So again, our experience is here for you. So enough about me. I think we should get to the heart of the matter, what we'll cover. So we're going to start with what I call the foundation of your estate plan, and that's decision-making documents. And then it's how we want to leave assets to our family in a secure way. And then, of course, protecting your assets if you need long-term care in the future. So I thought we'd kick off with some top 2025 New Year's resolutions. I always find them interesting. So number one this year was spending more time with family and friends. Number two was improving our health, eat healthier, exercise, weight loss, and to save money. So I always like to put these on. I think it's kind of fun. Where does it stack up with your New Year's resolution? I personally think getting our what I call house in order, making sure our estate plan is up to date, should be one of those resolutions. And that's why I like to start with it as one of our first webinars. So let's jump right in. Decision-making documents, also known as advance directives. Those are documents I do in advance of any sort of incapacity, so that in the event while I'm alive, if I cannot make my own decisions, I have nominated someone in advance to make those decisions for me. And that is critical because if I can't make my own decisions, I do not want my loved ones having to go to guardianship court to get permission to help me. So you do them in advance to make sure that the person that you trust and that you pick is the one making those decisions for you. So we have the advance directives, and they typically fall into three categories: durable power of attorney, healthcare proxy, and living will. The durable power of attorney is a document that gives someone the legal authority to act in your place for financial decisions. So, a durable power of attorney relates to financial decisions. Who's going to run your world? If you cannot pay your own bills, if you cannot speak to your accountant to file your taxes, if you can't speak to your lawyer because you're in a situation where your capacity has declined, then you want someone to be able to step in your shoes, a person of your choosing, to make sure that your financial world can continue. You can continue to pay your bills, they can continue to file your taxes, for example, and do all the financial things that have to be done. The healthcare proxy is a document that allows you to choose who would make healthcare decisions for you. This is critical. The healthcare professionals will always ask you first what you want, but in the event you cannot make your own healthcare decision, who is going to make that decision for you? And it's every decision. It's from the smallest decision, should I have this medicine, to should I have this surgery, all the way to end of life decisions. So it's really critical that you pick the person that's going to carry out what your wishes would have been had you been making your own decisions. And you nominate a person, and you can nominate successor agents after that. So, for example, if it were me, I could have my spouse, then my daughter, then my son, in no particular order. Um, and I can even choose whether I want to designate, yes, I'm okay with organ donation. No, I'm not. Perhaps I want to donate for research. All different things that you can tailor to make this healthcare decision your own. And you also want to consider putting your wishes in regarding artificial hydration and nutrition. Will they be withheld? Will they be given? All the different things. And it's very important that you speak to your practitioner to make sure you tailor it to what you want. So far we've done the power of attorney, which is for financial decisions, and the healthcare proxy, which is for healthcare decisions. The next document is something called the living will. The living will is your healthcare declaration regarding end of life decisions, right? So it says something to the effect of, in the event I'm in a permanent, persistent vegetative state, or I have a terminal illness, and but for these machines or these extraordinary means, I would pass away. This is your instruction to say what you want regarding the withdrawal or withholding of extraordinary or life-sustaining treatment. And again, just like the healthcare proxy, you can tailor this document to meet your own wishes. Some people put a time frame in. Some people say there has to be certain triggering events, but it must reflect your beliefs, including your desire to have pain medication or not, or whatever the specifics are. But this legal document is very important because not only is it your legal instruction to your proxy and to the medical professionals about what you'd want as to end of life decisions, but it's also your instruction to those you love that this was your decision and this is how you'd like it to be followed. Then our next slide is something called a HIPAA authorization. And many of you might be a little bit used to this when you go in for a doctor's appointment, for example, they ask you to sign a medical release, right? To make sure that they're not disclosing any private information that they shouldn't. So we encourage or we recommend that you do a HIPAA authorization. That way your healthcare agents, those you name under your healthcare proxy, is making a fully informed decision when it comes to decisions regarding your healthcare. They can access your medical records, they can speak to your doctors, because we never want anybody to be operating in a vacuum. So the HIPAA authorization is just a medical authorization which allows for the full disclosure and release of your healthcare information to the individuals that you've selected to make those healthcare decisions for you. Very important to have that information so that they can follow your wishes. So I get a lot of questions, and some of them are, well, what happens if I don't have this healthcare proxy? Right? Well, there is something called the Family Decisions Act, right? And the Family Decisions Act was implemented if there's no healthcare proxy and you're in a hospital or a hospice. So it's limited. It's not in every healthcare circumstances. And there's a pecking order in which people can make decisions for you. So, for example, it could be spouse first and then children. But the issue can be a couple of things. Number one, what if I don't have a spouse? Number two, what if I don't have children? Number three, what if I have multiple children? Which child is permitted to make the final decision? So that's just an example. It goes beyond that. But the point of what I'm saying is put a healthcare proxy in place so there is clarity, because clarity is the biggest goal you want to have when it comes to your estate plan. So put a healthcare proxy in place so there is clarity as to who you want making those decisions for you and in what order, right? Now, if we can't use the Healthcare Declaration Act because we don't have anyone that fits that criteria, and we did not use a healthcare proxy, now we find ourselves in a situation where we need a guardian to be appointed for our healthcare decisions. Same with the power of attorney, which I'll talk about in a minute. And you really want to avoid having someone to appoint a guardian for you to make those decisions. So put that healthcare proxy in place. That way you can comfortably assure yourself that your decisions are being made by the person who wants them. So what happens if I don't have a plan? All right. No one has the legal right to make decisions for you. Not financially, not healthcare wise. If you are over 18, no one has that right? So again, we end up in a court proceeding potentially where a guardian is appointed by a judge to make those decisions for you. So planning in advance is so critical because you want to make sure you have the individual or individuals that you trust to make those decisions for you. All right. We're going to now matriculate into our next section, which is how to leave assets to your family in a secure way. And many of my clients ask me that. That's one of their biggest goals. I want to leave assets to my family, but I hear all these stories, Kim, about things that are held up or will contest or something was missed. So how do I leave my assets to my family in a secure way? Well, it comes down to clarity again, right? You want to be clear and you want to put in writing what you want to have happen when you pass away. And the document that everyone must have if they're over the age of 18 is a last will and testament. Your last will and testament takes effect upon your passing. So when you pass away, your last will and testament comes into effect, and it essentially, I call it your roadmap as to your desires as to what you want to have happen. And you can change it during your life. Many people do. I call it ages and stages, and we have different relationships at different times. So our will can be adjusted, as we go through those stages. But it allows you to control who inherits your assets. And it allows you to appoint someone you trust to serve as your executor or to implement your wishes, right? And it allows you to provide for your loved ones in a protective way. Without a will, New York's laws of intestacy tell you who will get your assets and who will manage your estate. So it's important. Don't let some statute tell you where your assets are going to go. Put it in writing what you in fact want. And again, it's my word clarity. It'll be very clear for those who are inheriting and the executor who's managing your estate what they need to do. So, what are the benefits of a will? We talked about this already. You get to pick who inherits your estate. You get to empower the person that's going to manage it. You get to protect your loved ones. If you have an individual with special needs that is going to inherit, or you have a beneficiary with a creditor problem that's going to inherit, or you have a beneficiary with a potential marital problem that's going to inherit. Why not put it in writing that we leave them part of the estate, but we do it in a way that is protecting the asset for them and they won't lose it? Frankly, you will have peace of mind knowing that you put this plan in place to assure that your loved ones are provided in the ways that you desire. Protection with clarity. So then I always get the all important question. Well, when is a trust needed? I hear you, Kim. I need a will. I need my advance directives, which are my power of attorney, my healthcare proxy, my living will, my HIPAA authorization, and my last will and testament. That's the foundation of my estate plan. But when do I need a trust? Right? And there's different kinds of trusts. So really, it depends on what your planning objectives are. And when you go in for that planning meeting with your estate attorney, tell them, this is what I'm hoping to do. For example, I'm hoping to avoid probate. I'm hoping to protect my assets in the event I need long-term care. I'm hoping to protect a loved one because they have special needs or a creditor issue or anything that you want to protect them from. I'm hoping to save on taxes. These are just some examples of what some events or some goals are or planning objectives are when you want to have a trust. And a lot of times, it's not an all or nothing proposition. It's usually a hybrid. Many people want all four of these things. So when you communicate with your estate planning attorney, you tell them what your objectives are. And of course, anything that your estate planning attorney thinks you're missing, for example, we will tell you, okay, and what about this? And it's a dialogue and it allows you to explore all of your objectives and make sure that they get accomplished. So, to be or not to be, right? Revocable or irrevocable trust. Probably the most common blog that people review, the most common question I get. What's the difference between a revocable and an irrevocable trust? And when do I need one? Right? So I started with the revocable one. A revocable trust is a trust that you have full control over. You could be the trustee, you could take property in, you could take property out, you can access all the money. And people, you typically use a revocable trust when they want their family to have quick access to their assets. They don't want the cost of probate, so they don't want the surrogates court involved. They want it to be a private document. That way, when the person passes away, they just distribute the trust assets. And they want to avoid probate because they have real estate in multiple states, right? If I have real estate in New York, Carolina, Florida, for example, I don't have a trust, I will likely need to probate the will in all of those jurisdictions, in all of those states. Talk about time and money. So if you put them in a trust, you can avoid the need for all of that. Another triggering event is I have a family member that will likely challenge my estate. You're concerned that someone's going to contest your estate. If you have a probate, that person may be entitled to notice, which causes a stronger likelihood of a will contest. When you have a private document, it is often harder and makes more barriers if you are leaving unequal distributions or disinheriting one. So a living trust A revocable living trust is used when you want to avoid probate and you want to embark on asset management. But when does an irrevocable trust make sense? And you see on my slide MAPT, mapped. We call that a Medicaid Asset Protection Trust. There are various different kinds of irrevocable trusts, but a Medicaid Asset Protection Trust is the one I'm going to focus in on today because it has to do with asset protection and long-term care planning. So I would do a Medicaid Asset Protection Trust, also known as an irrevocable trust, when I'm worried about protecting my assets because I might need long-term care in the future. I might need a nursing home. I might need an aide in the home. I don't have any long-term care insurance. And I know that the cost of care where we live is so high. The cost to live in a nursing home in our area is approximately $16,000 per month. Not every few months, not per year, $16,000 a month. The cost of care at home is not far behind. If I need 24 hours a day, 7 days a week, and I am paying privately, I am well over $10,000 a month. So if you do not have long-term care insurance or you do not have the ability to pay privately, then you want to consider protecting your assets utilizing a Medicaid Asset Protection Trust. It's a separate entity that you set up, and you can fund it with your home, with your real estate, some of your assets, your non-retirement assets, and anything you place in this trust goes along what's called the 5-year look-back period. I'm sure some of you in this audience have heard of it. And what the 5-year look-back period is, it's a rule that says from the day you want Medicaid to cover you in a facility, they're going to look back 5 years and they're going to see if you made any transfers out of your name. And if you did, they think that you did it on purpose, and they're going to penalize you based on those transfers. So the name of the game is implementing this trust as soon as possible, making an asset transfer to that trust so you could start that look back period moving. By the way, here in New York, there is no implementation of a look back period for home care yet. They are suggesting 2.5 years, but it has not been implemented. All right. So we talked about the revocable trust, which is for asset management. You have full control. You can revoke it. You can change it. We talked about the irrevocable Medicaid Asset Protection Trust. It's irrevocable. You have less control. You have an alternate trustee, but it protects the assets in the event you need long-term care. So those cover two different things. But what if I want to set up a trust for someone, one of my beneficiaries? So while I'm alive, I have my own trust, but when I pass away, I'm really worried that one of my beneficiaries, for example, has a creditor issue or has a bad marriage, or there's some undue influence out there, a substance abuse problem, an alcohol problem, or they're just very vulnerable, right? You could do what we call in this office a family protection trust. We are very mindful of our clients' family and their desire and about their beneficiaries to protect them. And you can set up a trust so that their distribution or their inheritance is protected. It's protected from creditors. It's protected from bad marriages. It's protected from undue influence. It's there for someone who is on a means-tested program, such as Medicaid or SSI, right? All of these things can be put in place to safeguard that person's inheritance. And I always say, you're not punishing them, you're protecting them. And that's very important when it comes to your legacy. So a family protection trust is another option. And then the all important taxes, right? And it's very interesting, the field that I'm in, because they say you can't avoid death and taxes. So I have to address taxes. So we can set up trusts that save on estate taxes. So there's something called an estate tax, affectionately known as a death tax, and did I die with too much money in my name or too many assets in my name? So what the government does when a person passes away is they add up everything they own, the value of their houses, the value of their vacation homes, the value of their retirement accounts, their brokerage accounts, their checking and savings, their life insurance, right? Their annuities, anything that you own that has a value, it's added up. And then they look to see, wait a minute, is it over the estate tax exemption amount? So in the federal government says each person is entitled in 2025 to a 13,990,000 estate tax credit. So as long as I pass away with an estate under that amount, estate tax free. Okay. But New York is not as generous. New York says we'll give you a credit of 7,160,000 in 2025. And if you're under that, then you don't have to pay an estate tax. So what I want you to do when you're cleaning that house out for 2025 goals is to say to yourself, well, if I add everything up, am I over this limit? And if I am, I better get into Kim's office and make sure I'm planning so I don't have an estate tax problem when I pass away. And there's all kinds of tax trusts you can do. The annual gifting trust, a grant to retain annuity trust, a qualified residence trust, an insurance trust, a credit shelter trust, all different trusts. And we could go on for days about them. But the long and short of it is communicating, getting in there, implementing your plan so we can help you minimize estate taxes if you're in that arena. All right, so we're rounding out. It's 1:30. I know we started a few minutes late, so I'm going to take the liberty, just go over by a couple of minutes. But we're really in the summary phase. All the trusts that we're recommending avoid probate, which I know is a goal for many people. If you want to layer in that asset protection, then you're going to do an irrevocable Medicaid asset protection trust. And then you want to think about seriously how you want to leave those assets, your roadmap, and whether you want to implement a family protection trust to protect a beneficiary. And then when it comes to estate taxes, if you feel that you're over the estate tax limit, and we'll help you determine that, we're going to want to set up different types of tax savings trusts. So, in summary, when I have my estate planning goal, and I'm going to follow this rule too. I'm going to relook at my estate plan. It's been some time that I cracked it open. So one of my objectives for 2025 is to review my plan. And I'm going to just make sure that I have all my planning in place. I have my advance directives. I have my will, and I have my Medicaid asset protection trust or my revocable living trust. And speaking of that Medicaid asset protection trust, remember, if you're worried about how you're going to pay for your care and you can't pay privately, you don't have long-term care insurance, then you want to be preparing for Medicaid in the event you might need the coverage. And this is our summary slide on the Medicaid Asset Protection Trust, so we can protect our residents, some of our liquid assets, and maybe get home care or nursing home care in the event we need it. So, last two slides. When and why should I update my existing plan? Well, the rule of thumb is every 3 to 5 years if there's no event going on. So if you've already done your estate plan, Every 3 to 5 years, it's like a checkup, like going to the doctor. Check your legal documents, make sure they say what you want it to say and it does what you want it to do. The amount of times people open it up and they say, oh, my executor is not living anymore, things like that that you don't even realize. And then, of course, if there's a triggering event, a marriage, a new child, a divorce, a change in assets, you retire, you get a health diagnosis, or there's a death of a loved one. Those are events you want to come in sooner rather than later. So, as part of your resolution, if you have an existing legal plan, crack it open, take a look at it, go for a review. If you don't have your estate plan, please make sure that is one of your goals this year. So, what do I do now? I create that plan, make sure your legal documents are comprehensive and up to date, and you just get that plan implemented. So in sum, we've got our advanced directives, which are decision-making documents. We have how to leave your assets in a secure way, and you protect your assets in the event you need long-term care. All right. So I know we ran over a little. I pretty much have 1 minute because I estimated it to end at 1:35. So Russo Law Group is different because of our experience. We have been doing this since 1985. We have 3 convenient locations in Garden City, Lido Beach, Islandia. We've served over 17,000 families. There's 6 partners, 4 associates, many case managers and staff, all here to help you accomplish your goals. Just as an aside, the US News says we were ranked as the best law firm in the area of elder law. So I was really excited about that. So I see there's some questions in the question and answer. I'm just going to pull them up. And for those of you that need to drop off, I just ask that you fill out the survey. That way we can send you the recording. And for those of you who have to drop off because we're slightly over, I just want to thank you for joining us. So the first question is a New York State executed power of attorney, healthcare proxy, and living will accepted in other states? So the answer to the question is it is good practice if you move to another state to seek qualified advice there and do advanced directives in accordance with that law. However, if the document in New York State was executed properly when you first did it here, and there is an incident that happens in another state before you were able to do new documents, it will be effective. Okay. If I move to a similar question, if I move to a state, will the New York State documents be accepted? It's actually the same answer. Do beneficiaries on bank and other financial accounts trump what is stated in the will? That is correct. So if I have a beneficiary designation on an asset and I leave it to X, but my will says everything goes to Y, then the beneficiary X will inherit that asset. With an irrevocable trust, can I change the trustees and the beneficiaries, or the original ones locked in place? Great question. So the first thing I'll say is, look, all trusts are not created equally. I can only speak to the trust that we do in this law firm. I cannot speak to others, and this is not formal legal advice. But in our law firm, the Medicaid Asset Protection Trust, you are able to change the trustees and you are able to change the beneficiaries. Can IRAs be placed in an irrevocable trust? No. An IRA is an individual retirement account held by an individual person. So you would not put that in the irrevocable trust. As an aside, under the Medicaid rules, the corpus of a traditional IRA is actually exempt for Medicaid purposes. So you wouldn't put it in the Medicaid Asset Protection Trust, nor could you if it's in IRA form. Is there a time limit to trust? Example, only valid for 20 years, etc. So I'm going to give you the answer that you're looking for, and then I'm going to give you the law school answer. So look, your trust is going to last for the lifetime of the person or the life measuring. So for example, if I set up a trust and then the trust says when I die, it goes to my children, well, then the measuring life in the trust is my life and it gets distributed when I pass away. There is something under the law, it's called the rule against perpetuities, and that is to avoid what they call dynasty trusts going on and on forever. So it is the last beneficiary, lives and beings, plus an additional 21 years. That's a very technical answer. Your answer is whatever the trust terms say is typically when it terminates. If only if I own only one house in New York, can I leave my house to my two beneficiaries with a will? You most certainly can leave your assets to your beneficiaries in a will. But if you want to avoid probate, so you don't want them to have to go to the surrogate's court, and perhaps you want to add an extra layer of protection for health care, then you want to do a trust as well. You can certainly leave assets via a will, but there are definitely benefits to having assets held in a trust, even if you only have one house. All right. So thanks for hanging in there with me. Not too bad considering we started a couple minutes late. We're a couple minutes over. Happy New Year. I wish all of you a healthy, happy, successful at obtaining your goals New Year. And I, for one, am very grateful you joined me today. It's freezing cold. I'm sure you're glad it was a webinar. And I hope to see you. I hope to work with you. All right. Have a great day and a great 2025.